Okay, welcome to wakilsahab.com. Today is LFJ lectures number 13. This is Advocate Mehboob from Hyderabad. We have with us a eminent personality today, Mr. L. Ravichander. He is designated Senior Advocate of India, and he practices mainly in Telangana High Court and Andhra Pradesh High Court. He has been enrolled as an advocate in 1978, and he has more than 4 decades of advocacy experience. And he looks always young. And that's how we get motivated by his energy and his exuberance. He is a very eloquent speaker. He's a prominent public speaker. He's a debater. He's a MC. He's been called to a lot of events in law colleges for moot courts, for quiz competitions. He's a journalist. He's a blogger. He writes on a lot of important topics. He's also a film critic. In the recent times, I have seen him to become what do you say, clothing designer and a chef, a cook. So you have all the qualities of a polymath, I would say, mixed with the good proportions in one person. And this honorable speaker has been generous enough to come to us today to speak on a very important topic, that is public interest litigation, which has changed the course of public administration and public life and fundamental rights of India since last many decades. So I welcome Ravichander sir. Thank you so much for coming to our this thing talk, sir.
Thank you.
Thank you. You can go ahead, sir. Thank you.
Thank you very much for that wonderful introduction. Now, in the next 1.5 hours, I have the huge baggage of having to live up to that huge introduction given to me. First of all, I think this is a very nice and happy initiative that we have, and I wish it all success and hope more and more people make use of a facility of this kind. I'm told at 1 or 2 of the lectures, there were almost 100 people listening, which is a wonderful go. At such a stage, you must, to the organizers, get better speakers than me so that the registrations go up and they don't falter downwards. Coming to the main issue that is assigned to me, public interest litigation. I'll start off with a quote of Dr. Rajendra Prasad, our president, who at the adoption of the Indian Constitution said, so long quote, and I quote, "Whatever the Constitution may or may not provide, the welfare of the country will depend upon the way in which the country is administered. That will depend upon the men who administer it. It is right saying that the country can have only the government it deserves. Our Constitution has provisions in it which appear to some to be objectionable from one point or another. We must admit that the defects are inherent in the situation in the country and the people at large. If the people who are elected are capable and men of character and integrity, they would be able to make the best even of a defective constitution. If they are lacking in these, the constitution cannot help the country. After all, a constitution, like a machine, is a lifeless thing. It acquires life because of the men who control it and operate it. And India needs today nothing more than a set of honest men who will have the interest of the country before them. There is a vociferous tendency arising out of the various elements in our life." He continues, "I have no doubt that when the country needs men of character, they will be coming up, and the masses will throw them up. Let not those who have served in the past, therefore, rest on their oars, saying that they have done their part, and now has come the time for them to enjoy the fruits of their labors. No such time comes to anyone who's really earnest about his work. In India today, I feel that the work that confronts us is even more difficult than the work which we had been when we were engaged in the struggle. We did not have then any conflicting claims to reconcile, no loaves and fishes to distribute, no powers to share. We have all these now, and the temptations are really great. Pray to God that we shall have the wisdom and the strength to rise above them and to serve the country which we have succeeded in liberating. Unquote. I think this sums up the entire spirit of circa 1947. It sums up why this Indian Constitution is the spirit of this country. And it also tells us what lofty goals this country has made for itself and how constantly the oars are not for resting, but are challenges that we have to face ahead. I don't think there is too much of debate either on the fact that from 1950 to where I sit today in 2020, while much of what should have happened has happened, a lot of what must not have happened has also happened with the Indian polity. It is futile today to divide in the context of what I am talking to you about, whether the error lies in the court of the executive, the legislature, or the judiciary. Suffice it is to say that even today, that Gandhian dream of wiping every tear from every eye not only remains unfulfilled, but is a dream so far away that it looks like we have not even genuinely begun the journey. We all know, and it's too fundamental, that the Indian judiciary stands as that final arbiter between all powers in the country, and finally is the deciding factor as to how, who, and where matters will be. It was from the American Constitution and their Chief Justice who said, the law is what the Constitution says, and the Constitution is what we say it is. Therefore, today the law is the law as laid down by the courts, and as laid down by the courts is as laid down by the judges of the courts. There is no doubt also that for a long time in this country, we have had genuine problems about the rich and the poor. While today people may talk about contemporary governments not doing enough for labor that moved from one state to another, migrant labor in the context of COVID, let us be honest, right from the 50s, when the zamindari system was sought to be abolished, governments were found fault. And the voice of the rich, the voice of the powerful gained greater mileage. It is not new to our polity. It is not new to the world of politics. And it is not peculiar to India. What the American call class action, we in India call public interest litigation. And public interest litigation became that instrument by which the common man's cause, the common man's problem, came to be heard in the richest areas where very rich people could afford litigation, where lawyers charged amazing fees, where one day's fee of a lawyer could have been the lifetime earnings of some of the people whose voices needed to be heard in the context of the Indian Constitution. It was the wizardry, it was the wisdom of some great judges who said we need to move with times, who saw that the old concept of locus standi had become too archaic and could no longer be used in the context of dealing with the problems of the common man. Locus standi seems to be too technical a term, and we need to understand what it was. Locus standi necessarily meant the right of a person to litigate, to go to a court. Therefore, the traditional story was that he who had a grievance, he who was personally hurt, either in a civil sense of the word or in the criminal sense of the word, was the person who had the right to go to a court and sue and fight a litigation. For long, that was the only test, to buy a ticket to go to a court and fight a case. But then law had to change, because there were voices and causes which didn't have takers and buyers. And as a consequence of which, large numbers of people whose constitutional rights, both under Part 3 and Part 4 of the Constitution, suddenly cases were being filed without rhyme or reason. It was therefore considered necessary to lay down clear guidelines and to outline the correct parameters to entertain such public interest litigation. Parameters were required to be laid. They were laid down in the case of Sachidananda Pandey in 1987, and I just now read out to you the various guidelines that were laid down by the apex court, and how the Supreme Court, a very broad area from where people needed to start off their work. Before we go any further with the detailing, I must pause here to tell you that the shift was the vital beginning. Three important cases happened. One was S.P. Gupta. The other two was the Asiad case, 1982, and in the same year, the bonded labor case, or the Bandhu Mukti Morcha case from Uttar Pradesh. One dealt with bonded labor, one dealt with labor again in the Asiad, how they were being exploited, how they were not being paid wages, equal pay for equal work, women were not being paid proper salaries. These matters came up, and the Supreme Court from the 80s began to charter a new journey, different from what it did traditionally as the locus standi test work towards justice. We need to understand, therefore, that there was a socio-economic need or an understanding of the Indian Constitution from a socio-economic framework, as a consequence of which courts had to react. Courts could not be high and mighty. They could not sit in glass houses and say, you don't have the locus, we are not concerned, you are not hurt, therefore come to the court. Well, therefore, became the area where justice had to be extended to people who were denied, and some of the categories of the people who were denied would include the poorest of the poor, the depraved, the illiterate, the urban and rural unorganized sector of labor. Even now, I think when the Madras High Court dealt so poignantly with unorganized labor, moving, migrant labor, when the Supreme Court first stepped in with a whip, it was a sad state of affairs. But fortunately for us, the Supreme Court went on later to evolve a better pattern to deal with them. urban and rural unorganized labor sector, women. It is still unfortunate that women are still a large exploited group in the country, and the bizarre stories of rape that we hear are a reflection of how the Indian polity, and I'm not talking about today or yesterday, I'm talking about the Indian polity now for decades and centuries, have been looking down and been exploiting women as a gender, as a class. Then children, those handicapped by ignorance, indigence, illiteracy, other downtrodden who have no access to justice. At this stage, I must bring to your notice how our High Court has time and again, at least I can recall in very recent times, Justice Lokur, Justice Bosle, our present Chief Justice, Justice Ravichander Chauhan, constantly, quickly reacting to newspaper reports, taking up letters, and ensuring that bills are heard and heard seriously. As I talk to you today, I must also tell you that there's been a very interesting development in the High Court in Hyderabad. The Chief Justice not only takes up bill matters, letters that come or newspaper items that come, but he also ensures that these are not just dealt with academically, these are not dealt with in a routine manner. He ensures that designated senior counsels often are appointed as amicus curiae to help the court in dealing with these matters. I can tell you that senior advocates like D. Prakash Reddy, like Niranjan Reddy, extremely important, talented, successful lawyers are also asked, and even humble people like me are once in a way called upon to assist the court in dealing with matters which require public attention and which are exposed partly in the Fourth Estate. Therefore, there needs to come about a time when these voices are not only heard, and I think public interest litigation has helped the cause of this, especially in our state. Pro bono publico, good for the public. Courts intervened in pro bono publications when there have been callous neglect of policy of the state, a lack of probity in public life, abuse of power in control and destruction of environment, protection of inmates, of persons in homes, restrained exploitation of labor practices. Interestingly, as I talk today, there are cases before our court where dealing with people who are in jails, people who are in destitute homes, are being actively considered by our High Court. There have been, I think, 3 phases really in the origin and development of bill. Phase 1 was where there was a large consideration of Article 21, violation of Article 21, right to life, Mukti Morcha case, Mukti Morcha again, dealt with labor class where right to life was being seriously, Olga Tellis is another, where right to life was a serious consideration for people to work around. Then came about the second phase where cases were dealt with ecology, environment, forest, as a concept which we now across the country, and even today, notwithstanding green tribunals, courts are dealing with serious violation of environment. For example, the High Court in Hyderabad, I think week after week, is monitoring how late either disappear. People and social activists like Lubna have been fighting pill matters relating to environment, and the court is taking them all very, very seriously and monitoring. The third is probity, transparency, and integrity in governance. And it is here that I'm going to pause and, with a sense of sadness and personal sorrow, tell you that one of the champions of public interest litigation in Andhra Pradesh state and in Telangana, a champion who led it from the front, led it boldly, is no longer with us. I sadly would say that public interest will always Ramachandra. I brought him in the context of the third, also because he in public interest litigation brought in this very important concept of a new kind of a writ in India called the writ of constitutional accountability. He said we now need to move from the established writs of mandamus or a certiorari or a quo warranto or a habeas corpus, and then came to talk about a writ of constitutional accountability. He said people holding power are constitutionally accountable for their actions, and notwithstanding the fact that they may not fall within the definitions of a mandamus or a quo warranto or a prohibition, they need to answer. This was a giant step. I don't know, and I find it unfortunate and strange that people have not picked up this kind of a writ petition for constitutional accountability. And sooner than later, I hope somebody goes back to the archives and pulls out cases on the concept of constitutional accountability. At this stage, I would believe that I've basically given you a rough idea about how the concept works in this country. And I would like to pause here for a moment and tell you that there have been a number of cases. I don't have to list out those cases to you, but I would want you all from here to start asking questions so that I can respond to you. I would only ask you all to follow out M.S. Sivakumar versus State of Tamil Nadu, a 2005 judgment from the Chennai High Court, and the pill guidelines laid down by the Supreme Court, which is now open for all to see. And in this context, I would also voice a sense of disappointment as to how today, unfortunately, rules to monitor abuse of pill has led to cutting the nose to spite the face. It has become far more technical. You are supposed to file too many forms, tax returns, your willingness to deposit money if it is found to be malified, too much of extra paperwork, and it has reached a situation where one gets a feeling that it's even more cumbersome than filing a regular petition. I hope somebody someday will look at the rules framed either in the state or wherever they are in the courts dealing with pills. They're becoming more cumbersome at the administrative level, and hopefully it will become more liberal at the judicial level, definitely. Now, I hope that I've given you a bird's eye view of pill. I've told you how it has begun. I told you the necessity as to why pill became an answer to the traditional locus standi manner. More voices needed to be heard. The socio-political economic fabric of this country needed to be designed into a neater constitutional fabric, and that is why public interest litigation came in. Courts rightly saw its abuse and came on to say that certain categories of cases will not be entertained as pill. And today, a whole lot of area is being entertained as pill. I believe a lot more can. And here I pause to take questions from you.
Thank you so much for the excellent talk, sir. Thank you very much. And we have one comment from Sanjay Gadalia, sir. He's saying, as articulate as ever, it's always a pleasure to hear Ravi. Keep it up, very inspiring. Thank you so much. And
Thanks, Sanjay.
thank you. Let me start with with a question, sir. Like in terms of PILs, things are brought in a larger public benefit. So let's say there is a litigant who wants to come before the court and he does not have money to do so. So have the
Sorry, I
courts.
lost you. I lost you. You'll have to start again.
Yeah. The question is whether if there is a poor litigant who does not have money to afford a lawyer for a PIL, what should he be doing?
Something wrong at your end or mine?
Okay. Can you hear me now, sir?
Yes.
My question is, if there is a poor litigant who wants to file a PIL, who cannot afford a lawyer's fees, what are the ways a poor litigant can file a PIL?
Okay, is if he cannot afford, what can he do? There are multiple things he can do. One is there is a state legal services committee. There is a legal aid committee for the poor. The High Court, the State Legal Committee, and the High Court Legal Services Committee. You can go reach out to them with your petition on a piece of paper. They will place it before the Chief Justice, and the Chief Justice will decide what is to be done with it. Afterwards, sometimes what you think is a pill, sometimes may still fall somewhere between these many stools. Then what you can do is you can write a direct letter to the Chief Justice and request him through a letter to the Honorable Chief Justice, but I would advise address it to the registrar or to the Legal Services Committee, and then from there take it forward. There's a question from somebody.
Okay, sir. Okay. Yeah, Mr. Ibad, go ahead. Yes, Mr. Ibad, please ask your question.
Ensure he's unmuted himself.
Yes, Ibad, can you speak? Okay, he has texted it. How can a mechanism be created wherein frivolous PILs are stopped from reaching courts?
I have this theory that what the media can be there.
Uh,
Let us
I'm
err on the side.
sorry to apologize, sir. Your video and audio has been stuck for some time, and okay,
Now,
now it looks good, sir. Please go ahead.
now I would answer this. Now I would answer this question this way. Anything that is there is subject to abuse. You can use a knife to cut your vegetable. You can also use it to stab a person. You can use a nice fountain pen to write an article. You can also use it to throw ink on somebody's face. Abuse becomes a byproduct of use. Therefore, you don't stop the use. You police the abuse. How do you?
Sir, can you hear me? Ravi sir?
For relief in public interest
I'm
must
sorry.
come not only with clean hands, but with a clean heart, clean mind, and clean objective. Heavy costs can be imposed. Uh, it should not be publicity interested or private interested or pays income litigation, because there are people who blackmail. People in the name of writ petitions and public interest file cases and then withdraw them when they get the kind of money they want. It can be abused like that. Attractive brand name pills should not be used for suspicious products of mischief. When it has not been shown as to how or in what manner a party is handicapped, such writ should not be entertained. Jurisdiction should be invoked, and not every case should fall under that. Court should exercise its jurisdiction carefully and is a weapon to get at circumspection. This is what the Supreme Court has said. I know that there are times when some of these case privileges are abused, but if at the end of the abuse, justice is being done, then so be it, is my take on the matter.
Okay, sir. Um, Thank you. We have
Are we still there?
yes. We have Mr. Rao N. Rao Poturi asking.
Yeah,
Why,
yeah, yeah. Good evening, sir.
yeah.
Good
Hello.
evening.
Good evening. This is Jayan Rao,
Yeah,
sir.
good evening.
Good evening. Sir,
Yes,
one is
sir.
there, sir. This is a good instrument, PIL, no doubt. In certain cases, a good giving a good results. When it comes to the developmental activities, developmental as a national projects like dams, acquisition of land is required. When we have gone for the PL for the compensation and that, okay, the judiciary is coming to the extent of certain level only, but they are not totally justifying whether the sufferers got the proper compensation, what is the mechanism available to the judiciary after pronouncement of the judgment, really they implemented whatever the judgment has been carried out. And second question, there is a sustainability development. Always that argument comes into picture in PL cases. The sustainability development without destruction, there is no development for the nation. How to balance this? This is a major issue for the last 30 years it is coming. In the UN where,
Uh,
yes sir, this
yes.
is a primarily, this is a major area I given.
Oh,
The,
oh. Now, I'll take your third question first and then go on upwards.
yeah,
Sustainable growth.
yeah,
I think there's a judgment of W.C. Banerjee sitting in the Supreme Court, who said that we need to make a balance between growth and development and environment. But today, we need to understand, for example, when you say, I need development, I need to make progress, do we understand that the planet that we have inherited is not just man's planet? It's the planet of all beings on the planet. The fact that man can talk and engineer the planet is not good enough reason for man to exploit the planet beyond the point. Therefore, somebody needs to come in and police whether man is overusing the planet. One. Two. Also understand, the planet is not a now use and throw platform for us. If the use of the planet today is detrimental for generations like your children, your grandchildren, then it's a very serious matter. And then we need to understand whether we want that kind of a development. Understand that I keep saying this very often when people tear paper and just keep using it. I say, do you realize you've just robbed your grandchildren of 2 glasses of drinking water? Today, understand, in India, states are fighting with one another. Riparian issues are growing alarmingly because water has become a serious issue. So while to you, building a dam becomes important because you need dams are built for power, dams are built for other reasons other than water. You must understand that this is also a matter of great concern for keeping nature in its position and ensuring nature does not get disbalanced. So the question of sustainable growth is a delicate issue and something that experts on the matter will deal with. And that is why today the issue is not left with the judiciary completely. And that is why the court repeatedly tells people who raise these issues to go before the green tribunals, where there are experts who deal with whether this development that they are talking about is in keeping with the balance that is required to be kept. This is the first part. The second one that you asked was about how in development projects, people who are dispossessed of lands, etc., are not paid monies promptly. Strangely, as of today, as I'm talking to you, today the High Court in Telangana stopped the authorities from demolishing a building in Lalapet because compensation was not paid to them, though it was by consent that they said you can take my property and build it provided you pay some compensation. Also, after GOMS 123 came about in Telangana, number of cases came to be filed with regards to non-payment of monies to farmers and displaced persons. In fact, India has a history today of a lot of litigation under Land Acquisition Act, under the new Land Acquisition and Rehabilitation Act, wherein people who are dispossessed of lands are not getting compensation. The answer to that is go to the court. How do you make out whether the monies have been paid? Well, the court asks you to pay, and if they don't pay, you move the court back with a contempt application. I hope I've answered all your three questions.
So thank you very much. Mr. Potturi N. Rao is asking why central and state governments are not serious in implementation of the judgments given in PILs.
Well, one of the reasons could be lack of intent. Sometimes it could also be typically bureaucratic. For example, I can't understand why, statutory warnings are not followed. Things which, or there may be vested interests within these wheels, which ensure that these judgments are not strictly followed. And it is the duty of people, of active citizens, to go back to courts and tell them, here is your judgment, here it is not being implemented, or here it is being strictly violated by a government. So go back with another bill. Why governments don't do it? It could be lack of political will. Sometimes it could be lack of economic wherewithal. Sometimes it could be social indifference.
Sir, further, even if you take the latest case, Amaravati land pooling, sir. See, now your governments also coming with the typical terminology. We are not acquiring land. We are not taking acquisition. We are pulling the land banks, pooling of lands, land banks. They're coming with a new terminology. Purpose is the same. Purpose is the same. In the form of these land banks, a pooling of lands together, and one more, they are taking the help as the directive principles. Principles
Yes.
are the directives. They are linking with that. In that there is a no. We cannot go to the court also. Not enforceable. Not enforceable. Not enforceable in the court of law also.
Correct.
When it is come to the river. But sometimes the judgments are coming, the directive principles and the fundamentals are both are inclusive. Mutually inclusive, they are not exclusive. Sometimes the judgments are coming very strange, very strange. Sometimes no, both are different in each other area. Sometimes there is a constitutional scheme, these two. This comes under a constitutional scheme. So what your views on this, sir?
Two things. See, This theory that fundamental rights and directive principles are to be read as one whole is a theory that everybody likes to say but difficult to practice. Also, understand that courts have made it very clear that the directive principles are not executable, but it also says that once a directive principle has been given effect to withdraw it would amount to violation of rights, and therefore you can go to a court. That is some kind of a via media that courts have achieved. Two, if you look at the directive principles of our state policy, I don't think India is going to achieve them in the next 50 years. Whichever government, whoever is there, with the best of political will, I don't see all of them happening. I'm not even sure I want to see some of them. It's another story. Now, the other question is, when you discuss land pooling and how some courts say yes, some courts say no, on the same question, there are divergent views. How does the common man understand it? It's a question I face myself. I really don't know why there is such great variation between thought processes and why today, after 60 years, the clients of this country or the citizens of this country are still dependent on the ideas, personal, or the philosophy of the judge rather than its already stated interpretations. Now, one reason which is positive in that is that law is not a dead instrument. It is likely to evolve over a period of time. And in its evolutionary process, sometimes one set of people do suffer, but that is how society moves. And it's an inevitability that what was good law yesterday may be bad law today. And after all, a judge who is honestly interpreting a law, if he believes that a certain facet of the law has not been seen, or the space into which his judgment comes, he's entitled to do that. There will be differences, there will be contradictions, but as long as we are honest, we take it even if it hurts us.
Thank you so much. Let us move to other questions. Let me ask this. Okay,
Ravi,
Mr.
Mehboob, I'll ask my question. I just want to ask Ravi. Ravi, keep up the great
Yeah,
work that you're doing. Excellent session. I have one
thanks.
specific question, Ravi. I mean,
Who is
how
this?
and what? This is Sanjay Gadale here.
Yeah, hi Sanjay, yeah, tell me.
Hi. So, Ravi, PIL was like a Brahmastra that we had on our hands till the Supreme Court was operational and we could trust the constitutional process to actually fall in place. Today, every constitutional authority that has been mandated with the role that they need to play, whether it's the CBI, whether it is the Lokpal or even the CAG, have been mummified. And I don't know how to use the PIL in this scenario. How can I use the PIL to activate these jokers and make them realize their responsibility and work toward as demanded by the Constitution? How? What do we do?
Okay, Sanjay, there are two issues here. One is, I believe that the moral system of all of us easy for me to, or you to, wherever you are, to talk about how things are crumbling. Well, one way of looking at it is if it's crumbling, sit back, let it crumble completely, and then let's start building a new structure. The other is, after all, the desperate still don't give up hope. As long as there is life, there is hope. And as long as there are courts, there is life. So I believe it is the last sentinel. Sometimes even the last sentinel will fail you. Please understand this. The Supreme Court is not a warranty card for success and for wiping tears of everyone. Judges have perceptions. Judges can go wrong. The Supreme Court can go wrong. Only thing is, we will have to trust their honesty today. We believe that every time they err with honesty. And since they are the final, We have no choice but to live with their final verdicts, unless they fall within that area where they can be corrected by parliament or by legislative action. And then you go back to lobby with the parliamentarians to ensure that those judgments are corrected, or a new view is possible by fresh legislation. But as of today, I believe that the last sentinel of hope are the courts in this country. Are they supermen? They are not. They're human beings. They are as human as you and I are, but they are living in glass houses, and therefore they are more careful than others are.
Thank you. Thank you so much, sir. I will move to the next question of Mr. Ramakant. He's asking, to what extent has PILs contributed to the evolutionary jurisprudence in India? Has it brought justice to the poor by conquering the abuse of power?
The answer is a mixed one, yes and no. I think a phrase I used earlier in my soliloquy, that in the last many years, a lot of what should have happened has happened, and a lot more of what should not have happened has happened. I'd put Pill also there. I'd like to believe that Pill has definitely moved from the traditional locus standi and wiped tears in matters relating to voiceless people. It has dealt with labor. It has brought in a more egalitarian way of looking at men and matters. I think the political wing of the government today is far more careful while taking decisions on various things. They know that Big Brother is watching, so they need to be careful. So evolutionarily, yes, Pill has played a role. Has it played enough or not? I don't know, because it walks a tightrope walk. It does not want to be thrown off, or does not want to be perceived as somebody indulging in judicial activism outside of the Constitution. They also, it's also a very dangerous scenario if the judiciary starts running the government, because that is not the role that the Constitution gives to them. And after all, the powers that the Supreme Court or the High Court has is like that of a police officer has. Just as an example, I'm telling you, a police officer doing an encounter is unacceptable. It is against the rule of law, because the power he inherits is under a certain law, and he cannot go outside of that law saying, I'm upholding the law. This is also applicable to judges of the courts, of constitutional courts. All constitutions are about limited exercise of power. The Supreme Court is not the last Mughal in this country. It will also function within its limitations, and therefore sometimes it says, I may believe that what the government has done is wrong, but yet that is not an area into which I need to go in. I have my limitations, and therefore I stop. And this has both its advantages and its disadvantages, but I believe while it is judicially active, it must also be conscious of its limitations.
Thank you so much. Is there anyone who wants to ask any question on?
Sir, as you said, sir, PIL, if you look at this recent judgment of against this Mr. Shanti Bhushan, sir, 129, Article 129.
Prashant Bhushan.
Yeah, Prashant Bhushan. The Article 129 very clearly states, sir, that should be used very sparingly, that too on the public demand. That too on the public, that these two words very emphasized in the Article 129, and they never gone to the court's 1971 Act also. They never implemented in totality when the public interest registry filed on that. And when I am gone for the revision, no appeal there, revision or recall of the same, the decision, there also they are not accepting. It means that indirectly they're discouraging the PILs.
See, what I'm saying is this. I told you that the Supreme Court can be wrong. It can be wrong sometimes, but it is final. What choice do you have?
But so as I said, sir, there is a constitutional accountability is missing now. Now, when the man is suppose just I will coincidence with the government institutions and
Mr. Nursing, Mr.
constitutional
Nursing,
institutions.
Mr. Nursing,
Yes, sir.
please don't get into debates. This is a very
Not the debate, sir. Not the debate. How operating system I'm talking. The same concept, same concept. If the government institution, any executive does any mistake, he is accountable to certain is negligence of act or with wrongdoing. The same thing. Why not is extending to this? That is
Of
only that
course
I
it
am
is.
not
Of
saying.
course it is. Of course
That
it
is
is.
only that I am not
Please understand.
what countering or arguing this.
Please.
Just I am putting
Yes.
the views.
Okay,
Just I am
That's
putting the views.
I'll answer that question. Don't worry. See, one thing, what the Supreme Court has now said is not the final word. The whole issue is now before a larger bench. A larger bench is going to consider what are the parameters. Now, there was a time when judges were thought they were unaccountable, but then now we have judicial commissions. We have committees within courts which are looking at judicial action also. I agree with you that there must be a judicial ombudsman that does look into actions of judges of constitutional courts. I'm making this sentence with a great sense of responsibility. A judicial ombudsman that looks at complaint against constitutional authorities, including judges of the court, needs to be put in place. But the mechanics, the manner is very, very important. And unless that is largely debated, discussed, synthesized, and brought into a proper place, its use would be a dangerous weapon in the hands of people who are in power.
Thank you so much, sir. Very important things to be said. Number one is in the chat box, you can find the link to our YouTube channel. So we have the previous sessions. Mr. Sanjay Gadalia was asking about today's session. We are trying to record this and upload hopefully. And you can check out the previous lectures there. And there's also a Google form which I've shared in the chat box. If you click that, please give the feedback for our work so far and if possible for today's session. And I see that no more questions are coming up. I'll just try to conclude the session then.
One small query, Mohammed, if I'm given the permission.
Yeah, go ahead, sir.
Uh, I am extremely distressed about the way the RTI is progressing at the moment, the way it has been emasculated over the last 2 years. Ravi, you keep insisting on the ability of the person in front of you to assimilate, to be erudite enough as yourself to be able to understand and have the patience to engage. When you have the executive which is not doing any of these things, forget about the executive, even the judiciary is not doing any of these things. How do you break this jinx? Because these people are not willing to work on a solution. They are essentially working on an agenda to destroy the system. How do I take care of this?
Okay. Sanjay, I think it's this. RTI has failed in this country. On the other hand, it's very unfortunate that even that part of the RTI which was partly working is now sought to be amended under the present law. So I think I agree with you completely. But what is the solution? The solution is keep on knocking at the doors of the High Court against every. You have an original order. Against that, you have an appeal before the appellate authority. Then you have a second appeal before the commissioner under the Act, against which you have a writ petition. So there are 4 layers. Keep ringing each of the 4 bells in the hope that the RTI will become effective. In some matters it has, but I agree with you. I'm as cynical as you are about the failure of RTI in our country.
Okay, Mr. Ramakant is asking, sir, is asking that Honorable Supreme Court has exercised Article 142 in corporate matters. Does it exercise the same to PIL?
Of course it does. How else did Mukti Morcha happen? How else did Asiad happen? That they made luck. In fact, very interestingly, There's a bench now which has asked the Supreme as government of India to come up with a law within the next 1 month. Where do they get this power from? So they are exercising their 142 power in doing some of these things. They came up with a law saying that you need to do something about migrant labor and labor laws. A 3-judge bench recently, and they've adjourned the matter by 4 weeks. I think Justice Ramasubramaniam is one of the junior members of that bench. So yes, they do. But I'd like them to use it more often than they are doing it right now.
Okay. Okay, I see no more questions coming up. Thank you so much to the audience first for attending, and primarily, I would say to Honorable Speaker today, L. Ravichander sir. Thank you so much. You have been very articulate, very eloquent. You have taken all the questions, and we are really thankful for you generously giving us your precious time. Let me tell to the audience, sir has represented so many people from the highest places to the simplest men. I have told it earlier with sir's interview. He has the he had represent Chandrababu Naidu, the ex-CM, and also he has represented Y.S. Rajshekar Reddy, the ex-CM in Andhra Pradesh High Court, and many eminent person. So we are really thankful to you, sir, for generously coming today. Thank you so much. Have a good night, sir. Thank you so much.
Thank you. Thank you all for listening, and all the best for the initiative. I hope it goes from strength to strength.
Thank you so much to everyone. Thank you for the audience. Thank you so much.